All right, guys. Good morning. For me, it's good morning. Good morning to you. Good afternoon. Good evening, depending on when you are looking at this. And this is then, of course, recording number 2, the drafting of pleadings. So on a previous recording, I could say yesterday, but in that case, that would be wrong towards you. In a previous recording, we looked at the drafting of a particulars of claim. We looked at its structure. Do you remember its structure? Parties, jurisdiction, facts, and there with jurisdiction, facts, locus standi. You can bring it in usually at facts, or you can bring it in on its own. Then we went to the facts, then we went to wrongdoing, and then of course the consequent, the damages, whatever that was the situation there. And then of course, what do we want, which is followed up with those notices, those statutory notices that you attach usually, and then moving on to the press. And we saw that the press has to be relevant to the content of the particulars of claim. All right, and we used the respected Judge Hussein's drafting of skills guide there, one that you must purchase already. Maybe you have already purchased it. So that's what we did in recording number 2. But now we have to specialize a little bit. And on the reading list for your coming exams, you specialize fields in this. For the September exam is then, of course, damages, delict, and divorce. So guys, I hope that you had a good rest, except if you are looking at this in one go. And it's a lot, but it's a good introduction to the field of drafting. So I'm going to erase this. Maybe you can see this. Let's see if I can get it somewhere where I can also see it. There it is. There it is. Let's see if I there. Okay, it's a little bit difficult. Maybe you can see it. I hope you can see it. If you cannot see it, all right, there it is. There it is. Do you see it, guys? Okay, that is the Amler's Precedents of Pleadings by Harms. The Amler's President of Pleadings by Harms. This specific one is the 8th edition, and you must as soon as possible purchase this. Because you would see that Judge Hussein said yesterday that one shouldn't, especially if you're a youngster or a newcomer to this field, that you should not use a precedent like this. But if you use this in combination with that book, I think it's a very good idea. I actually used this from the very beginning because very quickly I became an independent advocate. And as an independent advocate, that's the way I took it forward. All right, guys, so that's it. That's it. We're going to be working quickly. Maybe this won't be such a long recording as yesterday. And we're going to be working out of this book. There's a couple of things I want to show you. And I'm going to take my time, obviously, with it because I want you to understand. Now, the first thing we're going to be looking at, but before we get to that, you would recall yesterday I said, listen, guys, you have enrolled, you're becoming an advocate. Sometimes it can be overwhelming. And I just want to say again, every time you see a recording of me, I'll motivate a little bit. It's absolutely worth it. It's a lot of work. It's difficult work. The exams coming up in September is not going to be a joke. And you should also not be repetitive. For example, if you've done your multi-choice and you've got everything about 50%, don't come and do it over and over again. You don't have time. You really don't have time, all right? So that's very important, okay? And as I'm sitting here, we've had our first registration. That person that registered yesterday, yesterday's date was the last day of May. That person will now know who he or she is. Congratulations, first registration for this program. You're the first person in yesterday. In the last day of May, we had one person registering. And we're very excited about it. Guys, you're making absolutely the right choice. Look at me, listen to my voice. I've had a fulfilling career and it's not over yet. And there's so much you can do with this qualification behind you. Becoming an advocate. The moment the court has made you an advocate, nobody can ever take it away. Yeah, sure, you can get into trouble with the LPC and all of those things. But if you're an advocate, then that says there's a certain qualification behind you. There's a certain experience there. And the court deemed it appropriate to declare you an advocate. And you can go and work privately. You can go and work in chambers. You can go and work for government. You can work abroad internationally. You can go over to Canada. There, if I'm not mistaken, you have to write a bridging exam. There's something there you have to do. And you can go on with your career there. So this is such a good choice. And please, guys, be positive. You have moments in your life that you become negative. Just overcome it. Just don't accept it. Aggressively overcome it. You're going to succeed and you're going to be successful. But you cannot be successful of this if you're a slacker. Don't be a slacker. I mean, it's got advocacy. Come on. Even attorneys. Come on. You cannot become an attorney if you're a slacker never in your life. All right. All right, so that's, I'm not going to talk too much about it, but I sometimes when I'm sitting here alone in studio, then I just get this feeling there's people listening to me, and they might be in a bad place. Get out of it. You're going to become a tiger, and that's what's important. All right, guys. In this book, I want to go to page 77 for those guys that's got Ambler's President of Pleadings. It is mentioned in your reading list, 8th edition, and I'm going there to page 77. Now, the first heading yesterday we spoke about was parties. You recall that was parties, né? So I want to talk about that a little bit. Remember, I said that now you know parties, you know it's plaintiff, defendant, you know it can be more than one plaintiff, it can be more than one defendant. But you still have to adhere to the rules. The rules tells you what has to go into these citations. I want to go through a few of them with you quickly. All right. So citation of parties, the first one I want to look there is, they say here in the Magistrates Court, every summons must set forth the surname, first names or initials of the defendant, by which the defendant is known to the plaintiff, the defendant's residence or place of business, and where known, the defendant's occupation and employment address, and if the defendant is sued in any representative capacity, such capacity. That is the defendant. All right. Now, just one thing I want to say here, I never use initials. Get into the habit of using the full names. I'll tell you why. I'm J. Clark, my father is J. Clark, my son is J. Clark, my brother is J. Clark, my wife, yeah, she's also J. Clark. So it's a little bit of a problem, eh? So for that reason and other readers, I like to go into detail. When I do particulars of claims for natural persons as well as juristic persons, because you talk about the directors too, I demand copies of the IDs. And I demand the win deed printout of the business, because I want to see if a guy is really a director, or if he was a director, he's not a director anymore, he doesn't have authority. Furthermore, still under natural persons, that was the defendant. Let's look at plaintiff. Full names, gender. Gender, if the plaintiff is a natural person, and occupation, and the residence of a place of business of the plaintiff, and if the plaintiff sues in a representative capacity, such capacity. And you can go and look at the Magistrates Court Rules 5, sub 4, 5, sub 4, and it will say that out for you. Now, if you comply with this, your citation of a plaintiff and the defendant is then 100% correct. And this is what I spoke of yesterday. You have to shorten template. You have examples in that manual from that excellent manual from Judge Hussain. And if you follow these guidelines, you can actually not go wrong. You really can. And you will pick up the legal jargon. Now, I know they say there's no legal jargon. I don't agree with that. If you read that POC, even in Judge Hussain's guide, you'll see the language there. It's a different type of language that you will speak with your friends, socializing, sitting in a restaurant, whatever the situation is. So that's important for me there. Now, again, with natural persons, let's have a look. Let's go to the High Court and see if it differs. Indeed, it does. There we're going to work with Uniform Rule 17 sub 4. Uniform Rule 17 sub 4. And yesterday in the guide, do you remember sub rule 17, 18, 19? I'm saying yesterday. So when I say yesterday, that means in your recording number 1. All right. So let's go look what we do in the High Court. And that is your house. That's not your only house, but that's your most important house. Every High Court and higher court, then a High Court, for instance, a Superior Court, is your house. Lower courts too, but this is your house. The High Court is your main house. You're going to spend most of your time in if you become a litigation advocate. The name, including when possible the first name or initials, I always use full names, by which the defendant is known to the plaintiff, the defendant's residence or place of business, and when known, occupation, and if the defendant is sued in any representative capacity, his or her capacity. Where will this happen? We saw this now with Magistrates Court and High Courts. Where will this happen a lot? If the person is a trustee, because with trust you sue them nomeo effusio, then obviously you have to use the capacity there. All right. And just another thing, I didn't say it with Magistrates Courts. What I also do is when I put the names in, and my client would say to me, but listen, we know him as Cappy or Stompy or whatever the situation might be. then I put that in brackets too. He's got a nickname or something by which he's known, then I put that also in there. It's all about identification, all right? It's all about identification. Nothing prohibits you from putting the ID number in there. There's no rule that prohibits you. If you can do that, that identification form is, of course, most of the time the best. Just don't make a typo error, where 7 you indicated as a 6 or something. Then obviously you've got a problem, because they can raise that as an exception. Say, but that's not me, that's my names. But a lot of people can have those names. But an ID number is unique to me, right through the world. Therefore, it's a problem here. Then you have a problem. So a lot of people, when they do this, they make stupid errors. Don't make stupid errors. Still in the High Court, under Uniform Rule 17.4, we also they have then the plaintiff. The plaintiff's full names, gender and occupation, and the residence or place of business, and when the plaintiff sues in a representative capacity, his or her capacity. So the plaintiff must then also, the difference, have you seen it? The difference there is the plaintiffs, you indicated gender, because remember, you will always act for the plaintiff if you set up a POC. You'll never start a POC from the foundation of acting for the defendant. There you're going to oppose, or whatever the situation might be. And then, of course, that person will say to you that what their gender is. Gender is not as easy as many years ago. Therefore, you cannot preempt, nice word, preempt what the defendant's gender would be, regardless what of that person's name is. So you cannot do that. But your client, the plaintiff, is sitting in front of you. I'm female, I'm male, whatever the situation might be. There's other gender roles also. That is then natural persons. All right, so that is still with parties. Remember now, we're busy teaching you how to cite parties. So I want you to go and give cognizance, due cognizance, to Magistrates Court Rules 5 sub 4 and High Court Uniform Rules 17 sub 4 also. Interesting, eh? Both are sub 4. Close corporation. So close corporation is a juristic person. It's not a natural person with full legal capacity. It must be sued in its own name, and full particulars of its registered address or principal place of business within the jurisdiction of the court concerned must be stated. Interesting. Listen to what I say. Registered address or principal address. When I say to you registered address, because a lot of people would say, but you know, I want to sue this closed corporation, but I don't know where they moved. Registered address. What does that mean? That means the registered address with CIPC. And I've many a times used that trick. People come and say, no, I say, all right, I'll pull a window and see what their last registered was, because the law says that when they move, they must immediately do a change of address with CIPC. So that is law. So you can actually get a default judgment against them if they've not done that. And most contracts you can draft. And I'm starting tomorrow in my time with the advanced contracts. And as I'm doing 4 sessions over 4 days in the corporate world from this webinar studio station where I'm sitting now. And as they are coming out, they'll be made available for you. You'll be receiving them. So if you access your site today and the advanced contracts is not there, they're coming out as I'm doing them this week and next week. And I'm sitting here today on the 1st of June. So you can calculate it from there. So I'm going to read close corporations again. I'm teaching you a trick here. That if people are starting to run around, you can't find this business. Sometimes they run away or they hide from SARS. You can actually get default judgments against them. Use the registered address when you can't find them. So closed corporation, juristic person with full legal capacity. And you can find that in Section 2 of the Closed Corporations Act. It must be sued in its own name and full particulars of its registered address or principal place of business within the jurisdiction of the court concerned must be stated. Right, that was closed corporations. So to give you, and of course in Judge Hussain, they said it out there, you can see it, you can use those templates there. Now one of the things you will say, even though it's a closed corporation, you will say, as duly incorporated under the Companies Act, every time you cite a closed corporation or every kind of company, because the Company Act has swallowed up the Closed Corporations Act, but because the closed corporations are still going on, you cannot open a new one anymore, but those existing ones going on, that is still relevant, but you can say there, duly incorporated under the Companies Act. I always do it. I always do it. Then companies. A company is also a legal entity separate and distinct from its members and directors. I'm happy to say directors. They say members there. Members predominantly actually has to do with close corporations. Close corporation has got members and companies has got directors. But in any event, it must be suit in the corporate name, same as close corporations. Full particulars of the nature of the company must be stated, as must the country of the company's incorporation and the company's registered address, or in the case of a defendant, a principal place of business with the jurisdiction of the court. So that is important. So sometimes what I'm actually talking here about country of incorporation. What does it mean? It means America has got a big corporate institution there, business registered in America, and they're the holding company, but they've got subsidiaries here in South Africa. Let's read it again and see if you understand it now better. It must be suit in its corporate name. Full particulars of the nature of the company must be stated, as must the country of the company's incorporation, which will be the holding company, and the company's registered address, or in the case of a different principal place of business with the jurisdiction of the court, obviously in South Africa. So although you can sue abroad, don't misunderstand me, this is how it has to be done. So how do I do it? I use the full name. I use the company's full registration number. I use the physical address because I want the sheriff to get to them. If I cannot get it, I go to CIPC and I get a last registered address. They must have changed it. I can get judgments against them because by law, that is the address they should be at. And then, of course, that's how I cite them. I will say duly incorporated under the Companies Act, and that's how I will deal with that. All right. And then sometimes I might even say I might actually work something in there about the directors if there's a necessity for it, although there is not. When they receive it, it will have the right strength you need to proceed. Interesting enough, I don't know whether you knew this, but when we sue a company liquidation, then that's a little bit different. There's a little bit of a different approach there. Did you notice? Most people don't notice. Let's have a look at it. This is on page 77. I'm reading from page 76 and 77 of Harms. Remember, self-evaluation. I'm not here to lecture, actually, although I'm doing that to an extent, but that's not my role, my instruction here. My instruction is to show you and to show you where everything is. You've got to find it yourself, but we're just gonna do it a little bit in detail. Do you agree with that? Because of my experience, I can talk around the subject, and maybe you learn something there, right? I'll make it as easy as possible. You're not an advocate yet. You're becoming an advocate, and let's see if we can get you there on an understandable foundation. Companies in liquidation. A liquidator of a company in liquidation may institute or defend legal proceedings on behalf of that company if authorized to do so. I've done a lot of them. In addition, the master of the High Court or the High Court itself may grant the liquidator the necessary powers. Now, let me explain it to you in a way you will understand it. When you have a deceased estate, who's the guy there that's got authority? That's right. Heard you shout over the whole country at the same time. Wishful thinking, I presume. The executor. So in terms of a deceased estate, executor. In terms of a trust, the trust. In terms of the company's liquidation, the liquidator. In the absence of any such authority, liquidators have no power to bring proceedings in the name of or on behalf of the company. So first he has to have that. He has to apply for that. He has to get it, and then it will be given to them. Now you can go and look at the Companies Act there. The old Companies Act dealt with that, and it dealt with it in section 386. But I would rather have you read the court case, ex parte Venterkey Spain, NNO, Fordham Factoring Limited intervening, Venterkey Spain versus Povey. So it was versus Povey. Please go and look at that. 1982 2 SA 94D for those guys who doesn't have this book yet. The liquidator ought to bring the action in the name of the company. However, a practice has developed according to which such actions are brought in the name of the liquidator in a representative capacity, and that is how I like to do it. Because that's how I showed to the court. This company it's under liquidation. The whole structure and foundation on which it operates is different. Otherwise, the judge has to, in his chambers, read through it before he actually gets to understanding what's going on here. And also there you can look at the section 386 4A. Shepstone, Kim Wiley versus Geyser case there. Gainsworth in a Transport Pty Limited, and in others case there's important. And if you buy the book, you'll be able to see what's going on. What I am going to do, so I'm talking about the Shepston case, I'm talking about a Gainsford case. I'm going to ask the administrators here to copy these pages and just to load them on that, or I'll make a list. You know, we don't want to infringe upon copyright. Let me rather type out the court cases. I'll send it through to them and they'll load it for you, right? So you know precisely where this is coming from. That is what I will do. That is what I will do still today for you this afternoon in my time. So that is how you deal with companies in liquidation. You can either sue a company's name, you can sue a representative capacity of the liquidator. Now go back to natural persons, because then you will use, if you're going to do it in his representative capacity, go back to natural persons. What did they say there? And any representative capacity, such capacity. So that's all you do. You will say so-and-so in his capacity of company and so, and you can, even in your parties, remember you're an independent thinker, you can say there under liquidation, etc., etc. You can put a court case in there. What I usually do when I do cases like this and I defend cases like this, I take the liquidation order, whether it's a final one or not, and I attach it to this. I first, and of course you're going to have to put down a court order where the court has ruled that you have the authority as the liquidator to act on behalf of the company. If you don't have that authority, are you dead in the water? No, what did we just say? Then you act totally in the company's name. All right. But all right, that's that then, because while it's in liquidation, while the liquidation has not been finally winding up, you have to protect this interest. All right. All right, going on to trusts. Let's talk about trust a little bit. A trust is not a legal persona, but a legal institution sui generis. Its assets and liabilities vest in the trustees. Trustees ought therefore to be cited as eo nomine in their capacities as trustees, since the trust itself cannot be either a plaintiff or a defendant. So whenever you cite a trust in their name, my name is James Clark, so behind James Clark in capital letters, you will have NO, nomeo officio, e nomine. Unless one of the trustees is authorized by the others, all of the trustees must be joined in suing, and all must be joined when an action is instituted against the trust. Now, very important, you're learning something. Did you pick it up? You cannot sue on behalf of a trust if you haven't read the trust deed. Because the trust deed will say to you, is there a controlling trustee or not? Now, in most instances, in a trust where I'm sitting on, I'm the controlling trustee. So then it's easy for me. I will be the nomeo officio. In the absence of that, all the trustees has to be cited. Are you with me? You got to read. You got to read. You got to read. Let's go back to closed corporations, especially companies. Let's go back to companies. Companies, you have to read the MOI, the Memorandum of Incorporation. And be careful when you read a Memorandum of Incorporations before you set up a POC. Sometimes they file with the MOI the shareholders agreement. There's a tip. You're learning something. A lot of people don't know this. So you must be make double certain whether the MOI, and it will be indicated for it will be loaded at CIPC, but that the shareholders agreement is part and parcel of the MOI. And that will also tell you how you can deal on behalf of your client when he or she or it is the plaintiff. In this case, it. Right, so that's that. Let's look at trusts. Unless one of the trustees is authorized by the others, all of the trustees then, and we have the Land and Agricultural Development Bank of South Africa versus Parker case, don't worry about it, I'm going to put something on the e-leader platform for you. Any person having an interest in a trust, whether as a trustee or beneficiary or otherwise, is entitled to apply for a declaratory relief when the status of trustee is at issue. This means that if that trustee, status of a trustee is at issue, and the status usually is he competent? Has he done something that is mucking around with his capacity? Has he died? Is he out of the country? Has he become mentally unstable? And then another trustee or a beneficiary on a trust can then step into that position, but they're going to have to apply for it. Cannot just happen out of them. And there you have Russ NO and others versus Van der Meulen, and Teron NO and others versus Loubser NO and others. And then they can act on behalf of that. Right, I'm paging now to page 78 of the specific book. And we're moving on. Now, when you cite trustees, it's the same as companies. It's the same as natural persons. You will cite a trust in his full name. You will cite a trust in his IT number. IT, India Tango. And I also cite them at a master where the trust is registered. I go a little bit further. And then there will be an address, everything, because when you register as trust, you have to put it up. And what you have to do then is you have to look at a trust deed, and you have to have the official registration papers with the master's office. I have this habit when I cite parties on the natural persons. Listen to what I'm saying. I attach. I have this habit. You don't have to do it. I don't force you to do it. I attach a copy of the ID books. I always do it. There's your picture. Have a look at it. Companies, close corporations, their registration numbers. Deeds office, their official registration. You will know now, or maybe you don't know, is that when you register a trust currently, it's not like in years ago where you just file the trust deed and a couple of documents. There's a big list that you have to fill in with a lot of information. I've totally changed it now, a couple of years ago. So I file all that official paperwork on the parties. I would say the plaintiff so-and-so, run through it as per annexure so-and-so, being this number document with the master's office. That's what I do. I really make certain I have the right people. I make really certain that there is no comeback. Then on page 78 of the amblers of harms, executors and trustees of estates. They say we can have a look at deceased estates there. And deceased estates is the same. It's a natural person as the executor, except if the executor is a juristic person, for example, Absa Bank. So don't be alarmed. It's easy. You fall back to Joe Smo, who's the executor of Absa Bank, is the executor. You fall back to them. You go back to the page where we dealt with natural persons or juristic persons, and then all that will happen there is the capacity as executors. Trust, capacity as trustees. Close corporations, capacity as managing member. Companies, capacity as managing director, or whatever the situation is, CEO, chief executive officer, whatever the situation might be. All right. So that is parties. That's what we spoke in the first clip about. Parties. It's easy. We know who the plaintiffs are, but now we need to do it right when we do dissertations. Government and state officials. The citation of ministers of state and public officials in their official capacity is regulated by statute. They must be cited by their official title and not by name. And there we have the Department of Public Works versus MS Moss that you can have a look at. In any proceedings against the state, a minister of the department concerned should be cited as the nominal defendant or respondent. This also applies to a member of the Executive Council of a province. And there we have a YEA versus MEC of welfare case. In appropriate circumstances, Director General of a department may be cited in his official capacity. The Discord Export Partners versus Director General of Department of Trade and Industry case in 2005. Action may also be instituted to defend it in the name of the state. And there we have Killian versus Gauteng of the provincial legislature in 1999. So usually when I cite government officials, I have a habit of putting everything in there. I have to put in there. But don't worry, I'm now talking about it. You're already like, oh, how am I going to draft it? Oh, no, no, no. I'm going to show you now precisely how to draft it, word for word. I'm just telling you what is the theory and the academica behind it. So that's government officials. And please always consult the State Organs Act there. Because the State Organ Act, actually, for example, the SAPS, we've done a lot of cases against the SAPS. You can either go for a minister, you can go for the commissioner or the deputy commissioner in that province. Well, actually, not the deputy commissioner, the provincial commissioner of that province. All right, I've done it a lot. So go and consult the State Organs Act to make certain, because they give you a listing there of what has to be done, what's the terminology to be used, etc., etc. And then you can get it right like that. What about partners, firms, and unincorporated bodies? Now, what does it mean? What is an unincorporated bodies? Companies, close corporations, blah, blah, blah. They incorporate under the Companies Act. So this is anything. This is anything that's not officially registered under the Companies Act with CIPC. All right? Partnerships and so on. Actually, partnership says it to you. Me and you, we engage a partner. Where do we register that? Do you understand what I'm saying? Persons claiming to be sued as partners may sue or be sued in the name of the firm of which they were partners when a cause of action arose. Any person carrying on a business in a name or style other than her or her own name is sued to be sued in that name or style as if it were the name of a firm. The provisions of the rule apply mutatis mutandis to an unincorporated company, syndicate, or association. A partnership firm and association may be sued or be sued in its name. A plaintiff suing a partnership or firm need to state the names of the partners. A voluntary association for gain is not a valid legal entity if it has more than 20 members. It has no legal standing. Let me read that again. A voluntary association for gain is not a valid legal entity if it has had more than 20 members and there's no legal standing. All right. So that is partners and firms and unincorporated bodies for you. So that is the criteria behind that. Don't worry, don't stress. We're going to show you now how this works. Public corporations. Public corporations are usually created by special statute. Their corporate status and established statute ought to be stated in any relevant pleading. So from page 76 to page 78, we have the academia, the theory behind this. Now, I'm going to read to you slowly. How does these citations look? So listen, what is beneficial to you is you can literally rewind this recording if you have a problem. All right. So even if you don't have the book, don't get alarmed. How do we cite natural persons? Are you ready? Here we go. The plaintiff or defendant is Mary Smith, an adult female bookkeeper. You don't have to say female if it's a defendant. Residing at, address, whatever, or having her business at whatever address, or employed at whatever address. Again, here's another one. The plaintiff defendant, which what is the situation, is Mary Smith, an adult female bookkeeper residing at address, or having a business at whatever address, or employed at whatever address. Listen up now. Who institutes this action, who is sued in her capacity as mother and sole guardian of her minor son, John Smith. All right. Another one under natural persons. The defendant is M. Smith. I don't like doing that at all. An adult female whose further particulars are not known to the plaintiff of address. Guys, you cannot sue if you don't have an address. Where is it going to go? So you must have an address or a last address or whatever the situation is. So we do use whose further particulars are not known to the plaintiff. That happens sometimes that you don't really know the full details. Maybe it's a defamation case or something, but at the very least, you must determine an address. Without that, you're going to have to appoint an investigator or a tracer to trace these people before you can act. That then is natural persons. All right. Close corporations. Listen up. Here we go. The plaintiff or defendant is J. Smith CC, a close corporation, incorporated in terms of the Close Corporation Act 69 of 1984. Nowadays, I say the Companies Act, which with its registered office as at address so-and-so, with its principal place of business within the jurisdiction of this court at so-and-so address. All right. And remember that registered address. It's helped me a lot. You can pull that from CIPC. You do a wind deed search. That's a close corporation. Now, companies, the plaintiff or defendant is J. Smith Key CO Pty Limited, a company with limited liability, incorporate, and remember it's only a company with limited liability when a company with limited liability is applicable. You have to go and look at the Companies Act, what a kind of liability pertaining is. Incorporated, in terms of the Companies Act so-and-so, I used the New Companies Act citation. This one is still the old one. With its registered office at whatever address, or with its principal place of business within the jurisdiction of this court at so-and-so address. Okay, easy enough now. Companies in liquidation. The plaintiff, so we do a natural person approach, or the defendant, whatever, is J. Smith Key Company Pty Limited, a company in liquidation by order of court, and the details herein represented by its duly appointed liquidator, named so-and-so, and detail of appointment. Because remember, the court appoints him. So, and what I do further with all of these things, I attach ID books, I attach registration forms of the companies, etc., etc. Another one for companies in liquidation, the plaintiff or defendant is, whatever the name of the liquidator is, here incited in his capacity as duly appointed liquidator of J. Smith Key Company Pty Limited, a company liquidation by order of court, and then full detail of that. And there I always annex that court order, because that supplements the detail in case I leave something out that the judge might want to look at. All right, now you're learning, right? Now you feel better, because when I spoke about it, that's the academia approach. This is the practical approach. Government and state officials, you ready? The plaintiff or defendant is the Republic of South Africa, herein represented by the Minister of whatever department, acting in her official capacity. Best one to use. Best one to use. Not so complicating, easy to run with. The next one, also under government and state officials, the plaintiff defendant is the President of South Africa / Minister of whatever department / Premier of the province of what province / Director General of what department, acting in his official capacity. And then remember, under the police, you'll go to provincial commissioners and commissioners too. So go and look at all those military, paramilitary institutions. The Organs of State Act actually gives you more. This is not all of them, but this covers also the provincial commissioner and the commissioner of SAPS, because you can do the Minister of Security, then he's covered. Partnerships, firms and associations. The plaintiff or defender as a mega trading, a partnership, whatever firm, trading as retailers and having its place of business at whatever address. It's a partnership, so there won't be a registered address at CIPC. Another one here you can use is the plaintiff or defendant is Gauteng Tennis Club, quasi institutions, a voluntary association and tennis club of so-and-so address. So that is then partnership, firms, associations. That is then quite easy there. The last one we're going to deal with is then that public corporations. And I must say, I didn't have a lot of these cases, but there's a lot of public corporations like Transnet and Telkom. I think I had a case against Telkom in the past. The plaintiff or defender, whatever you're going to do there, is the South African Inventions Development Corporation, a body corporate established by Section 2 of the Inventions Development Act 31 of 1962. All right? The plaintiff or defendant, whatever, is Telkom SA Limited, a public company contemplated in Section 3 Sub 1 of the Post Office Act 44 of 1958. What about Transnet? The plaintiff defendant is Transnet Limited, a public company incorporated in terms of the legal succession to the South African Transport Services Act 9 of 1989, read with the Companies Act, of course, then the new one. So there you are, ladies and gentlemen. It's as easy as that. All right. And then you can go and read further on pages 79 to 83. They give you a couple of things that's going on there in terms of close corporations. They give you some of the sections there and court cases. That's important. We will definitely give you a summary on that so that it can be filed under this teaching, and then you can have a look at that. All right. So that sums up parties. Give me a moment. I'll be back in a second or two. All right, that's just my sinuses playing up. By now you ought to know me. It's this season of the year. From when I was a small boy, I always had sinuses. All right, so now you've learned that a citation of parties is not that difficult. You must know where to put it in your POC in the beginning, and you must follow the rules. You will always be fine. And it's not that difficult. I remember when I started out, parties citation was very, very intimidating for me, especially when I said government officials. I was like, hey, what do I do here? Companies, what do I do here? It is not. You don't have to wreck your brain around it. It is quite easy to do. All right, guys, we're going on now. We're going to keep going slow. We're going to be looking at damages claims. All right. So that's what we're going to do. Now, a damages claim is delictual claims. All right. So we can look at delictual claims, the drafting of a particulars of claim in general, or we can look at it specified in damages. So we'll be looking at it generally just after this. I first want to deal with the damages section with you. All right, do you have that cup of coffee? Are you ready? This is on page 145 of the Amblers. And let's have a look at it. The first way we're going to approach it is in general. A plaintiff has to allege and prove the quantum of damages suffered as a result of the defendant's wrongful act. So that's on you. You've got to remember that. Eh? Whenever you do a damages claim, obviously, what is the most important aspect you have to prove? And that is the quantum of the damages. Now, we spoke about that yesterday. Do you remember? Not yesterday, in clip number 1 for you. We showed you down there that you cannot just claim damages. It has to be broken down, right? And the court has discretion. So sometimes you cannot break it down. I want to say this to you. There is cases where you cannot break it down. For example, where somebody have insulted me in public. And now I'm suing for 400,000 rand, all right? Unlawful arrest. I remember I did a case we sued for 250,000 rand because she was detained for a period, a couple of hours only. They gave this 60,000 rand. But there is a criteria there. The court there with unlawful arrest and detainment, I have to admit, there is a criteria there. So that is important, all right? So, but if I call you this and as that, what is the criteria? What is the criteria? So that sometimes you will put an amount there that you feel is justified and a court will break it down. In other circumstances, you have to be specific. I always had to be very specific when I drafted particulars of claims for medical negligence. All right, let's see what I was saying here. Let's learn something about it before we take on the situation of actually an example and see how we do with that. So that is then, of course, the damages. They also say here, a plaintiff claiming prospective loss, damage or loss which has not yet materialized, need not prove on a preponderance of probability that such loss will occur or arise. Instead, a contingency allowance for the possibility of the loss is made, and that is futuristic damages. For example, medical negligence cases where you have gotten hurt now, but in the future that can impact on you over 10 years. Due to that injury, you've got other serious injuries, your health is going backwards, etc., etc. A defendant who in the plea admits liability for payment of damages, but for an amount lower than the claimed need, not particularize the admission, nor does the admission attract any onus. Difficulty of proving damages. If damages are difficult to determine or cannot be assessed with certainty, the plaintiff is entitled to judgment upon production of all the evidence that can reasonably be produced to enable the court to assess the quantum of the loss. Now, I just saw a recent court case. You get this actuary book. It's been released every year, a couple of every years, and it's got all these averages in which for specific cases you can claim. And I actually saw a court case the other day where a judge says, well, that's a good book, but that doesn't tell me what to do. That is not a piece of legislation I have to adhere to. So here you see it. It's not always possible to calculate specific damages, and then the court will then decide on that. It's not a bad idea to take that actuary book in there, because that is on average, they work it out, the actuaries, but don't force it down the code. In this case, I think they became pompous to say, but the court's got to listen to this code. That's not a law. It's a private entrepreneur, private entrepreneurs that puts that up. Allocation between co-defendants. If it's not possible to establish how much of the damage sustained was caused by each of the co-defendants, and it is clear that all the available evidence has been laid on the point, it is the court's duty to do the best it can. This may lead to a finding that each defendant is liable to pay half or some other portion of the loss suffered. So when evidence has been deduced, the witnesses has been led, the court will make that call to see who has to pay what. Hopefully you have that clauses in there, several jointly liable, and that will then actually, on that foundation, the court will then move forward. Actuarial calculations, this is what I spoke about. Actuarial calculations provide a guideline only, and the court is not bound by them. And the Lambrowski versus Santam case in 2000 was the case in which that was says. There's other case where the court was actually very adamant about it. Once and for all rule, in general, a plaintiff must claim in one action all damages flowing from one cause of action, whether already sustained or prospective. The once and for all rule. And they say in general, they start a sentence in general, but I can tell you it has to be 99.999% of the time. That it will only be conceivable where you can bring another claim afterwards, where there was no phantom of imagination prospect that something else could have happened or went wrong or you missed something. Measure of damages. A plaintiff entitled to recover from the wrongdoer the amount by which the plaintiff's patrimony was diminished as a result of the wrongdoer's conduct. The measure of damages is the value of the article to the owner and is determined on the day of the commission of the delict. All right. So the date on which it happens is an important thing there, and the value of the article to the owner. And that can be anything. Don't be misguided by article. Don't be misguided by owner. To prove that amount, the plaintiff may, in respect of damages to an article, prove the reasonable cost of repairs to the article to restore it to its original state, or the difference between the pre-delict value and the post-delict value. So if it is a physical article, that's the way it's done. But don't be fooled by that whatsoever. The plaintiff is entitled to the lesser of the two amounts and has to show that the measure chosen is the correct one under the circumstances. The plaintiff is entitled to the lesser of the two amounts. So if there's various amounts, it's going to be the lesser one. A plaintiff who relies on one of these methods in the pleadings is not necessarily disentitled thereby from using the other method to prove the amount of damages. It is unlikely that the defendant would be taken by surprise in such a case because of the requirement for expert summaries, so that is a benefit. In respect of the complete loss of an article, so it's not damages, it's gone. The plaintiff must establish its market value or replacement value at a date of the delict. On the day they stole my vehicle. Or it was written off. On the date it was totally written off. You cannot repair it. Something like that. In determining quantum, no regard is had to the detrimental consequences of the delict or to any advantage results arising from it. All right, guys. Let's look at personal injury claims. Let's see what I do there. For personal injuries, the plaintiff is entitled to claim actual pecuniary loss, such as medical expenses and loss of earnings, pain and suffering, actual pecuniary prospective loss, such as future medical expenses and loss of future earnings, actual pecuniary loss or earnings capacity. Actual loss implies a diminution of the plaintiff's estate. So what happens is you have an estate and it's actually devalued, not devalued, but you have a physical loss in the monetary value of it. There you are. And the word I'm using there is diminution. Ah, not good for me at all. You can go look at that at 147. Let's laugh about that and move on. Assessment of general damages. Although a plaintiff is entitled to full compensation, the award must also be fair to the defendant. Now, this happens a lot when they say, but you were 20% liable and the other party was 80% liable. There's a lot of that criteria going around. If the loss cannot be quantified, the court has to exercise its discretion, taking into account previous awards and the trend towards conservatism. And that is then important there. How does this operate? Conservatism, sorry, conservatism. I'm fumbling over the English words this morning. So what can assist you then there is the actuarial calculations. All right, so the actuarial calculations is very important there. So if you have your guide there, then that can assist the court. All right, particularity of damages. You can look at Uniform Rule 18, 10, 11, and 12. That's 18 sub 10, 11, and 12. And you must comply with that when you go into particularity of damages. For example, are you ready? A plaintiff suing for damages shall set them out in such a manner as will enable the defendant reasonably to assess the quantum thereof. provided that the plaintiff suing for damage for personal injury shall specify his date of birth, the nature and extent of the injuries, and the name, effects, and duration of the disability alleged to give rise to such damages, and shall, as far as practicable, state separately what amount, if any, is claimed for. Medical costs and hospital and other similar expenses, and how these costs and expenses are made up. How they are made up. Remember what we said in the first clip? You're going to say, you specify. Pain and suffering, stating whether temporary or permanent, and which injury is caused it. Disability in respect of the earning of income, the enjoyment of amenities of life, giving particulars in the English is returning to me now, and stating whether the disability concerned is temporary or permanent, and disfigurement, with a full description thereof and stating whether it's temporary or permanent. A plaintiff suing for damages resulting from the death of another shall state the date of birth of the deceased as well as that of any person claiming damages as a result of the death, and we are looking at minor maintenance or spousal maintenance. If a party fails to comply with any of the provision of this rule, such pleading shall be deemed to be irregular step, and the opposite party shall be entitled to act in accordance with Rule 30. So those are the things you can go and look at. So that's on page 145 of the Amblers. And if we go further, we look at mitigation of damages. You can go through the rest of it, just leading it through you so you have a better understanding of what's going on and giving my take on it, how I understand it as an advocate and how I have applied it for years. Mitigation of damages. A defendant may prove that the amount claimed by the plaintiff does not represent the true amount for which the defendant is liable because of the plaintiff's future to prevent the accumulation of loss. Reliance on such failure requires a positive allocation to that effect and attracts an onus. Interesting enough is when I read this, hopefully a lot of you say, oh, all right, settlement. So if you are in a case, you can see they can really prove that you claiming 100,000 Rand, but they can prove that it's only 50,000 Rand. Be careful. You can be punished by a cost order if you pursue that in the face of the fact that it's clear cut that that is the situation. Then you can move into settlement and settle this. A defendant who proves the failure need not quantify the amount of damages. The plaintiff must still prove the extent of the damages suffered. All right, so that is the benefit for the defendant making that allegation. A court should not be astute in holding that the defendant has discharged his onus. So that's very interesting. If the plaintiff comes and his testimony is indicative of the fact that, yeah, all right, there might be a discrepancy, it does not mean that the defendant stands idle. If his allegation is made too generally, in the fact that he's alleging that that is not the full amount of damages, it is overestimation, then the court must also listen to that, must keep their ears open to what's happening on that side. The test is one, of course, of reasonableness. All right. Let's move on to what we call collateral benefits. Collateral benefits, man. That English has returned to me now. Generally, any compensation a plaintiff receives from a collateral source wholly independent of the wrongdoer does not reduce the damages recoverable. I want to read this again. Generally, any compensation a plaintiff receives from a collateral source wholly independent of the wrongdoer does not reduce the damages recoverable. So this person on the left created all my damages. Suddenly here from the other side, one of the persons is coming and giving me money as compensation. Now you would shout in Dublin rule, if it's totally independent, wholly independent, that money received does not decrease the damages claim. All right, does not reduce the damages recoverable. Remember this, because a lot of litigators don't know it, and they say, hey, you can't transgress the Dublin rule. Be careful. Here you can. And a lot of guys don't know this. And this is on page 149 of the Amblers. The exact limits of this rule cannot be stated succinctly. Nice. For instance, in ascertaining a plaintiff's loss due to an infringement of earning capacity, every benefit under the contract of employment and bestowed as compensation for loss of earnings or earning capacity must be deducted. On the other hand, benefits paid as a form of solatium or out of generosity, and generally insurance payments are not deductible. Insurance payments will transgress the Dublin rule, because that's not totally independent, are it? Because you have ceded your claim to them. So you can get payment from both. if the insurance company has paid you out under the law of subrogation, you have ceded your claim to them against the wrongdoer. All right. So there the induplin rule applies because they're not totally independent. It's interesting. Eh? I love this stuff. And you must love law to be effective in it. And when I go through these things and I see how it comes like a puzzle together, and how you can play with it, and how you can deal with it and apply it, this is really. And if you're going to make a career out of it, you must have affinity for it. You really must. When damages are assessed for loss of support as a result of a person's death, no insurance money, pension, or benefit which has been, will, or may be paid as a result of the death may be taken into account. Same application, it's insurance. All right, what about the inquiry into damages? What about it? Can we inquire into damage? How does it work? What is this all about? A plaintiff who wishes to have the issue of liability decided before embarking on quantification may claim a declaratory order to the effect that the defendant is liable and pray for an order that quantification stand over for later adjudication. All right. A lot of judges don't want to do it. They say, okay, we are differing the matters from the quantum. To heal the matters, you can win the matters, but we'll quantify the quantum later, quantification, nice English word. And there's some judges that will not allow this. Because really, sometimes it can be a waste of time, and sometimes it's a strategic legalistic maneuver from the opposition or the side that's playing for time. And very interesting, very interesting. But if you have a good argument and there's a reason for it, then of course they will order that. It's something that you can actually decide on. Most of the parties in front of the court come together and they decide on it. But even if they decide on it, I've seen justice that says no, they will not tolerate it. They actually say, very well, you've decided on it, get in the box, tell us about it. Tell us about it. And then they say no. Accordingly, a plaintiff is entitled to claim an inquiry into damages. Applicants in motion proceedings are likewise entitled. If the party is unable to reach agreement about the future conduct of the case, of any case, any party must apply in terms of uniform rule 33 sub 5 for direction. And that's it. That's that for what we've now done here in terms of the lictual damages. So that's the lictual damages. All right. All right. That's cool. That's cool. Eh? Now let's go to page 165. And let's have a look at delict. And in this specific one, we will look at a template, a precedent of a POC. And I only give you sometimes the short version. I don't always put the parties in if they feel that's unnecessary. And this is why this can be dangerous, because it can be misunderstood. But enrolling in this program, and listen to the clips, and listening to what we are doing here, reading up on everything, you have all the tools at your availability to make certain you don't make mistakes. And that you can actually start practicing as a pupil if you are successful with your admission exams and you are accepted in chambers or by an independent advocate. All right. Now, delict damages, the lictual damages, injuria lex aquila, depositum. Right, depositor's claim. Now let's see what they say here. A depositor's claim against the depository is for either the return of the thing deposited or its value. The depositor must allege and prove a contract of deposit, the delivery of the thing to the depository, the value of the thing if this is claimed. Non-return must be alleged but need not be proved. So when you go to page 165 and you start putting up the lictual claims, this is the theory you take, the academica, and this is what you then transverse over into practicality, and in practice draft your particulars of claim. If the thing was returned in a damaged condition, the fact and the amount of damages claimed must be alleged and proved. Ownership of the goods is not an element of the claim. So you must allege it, make certain when you read all of this stuff. And this is also why the precedence is sometimes dangerous, because people go to the precedence and they copy it, but they never read the instructions, the court cases that guides these precedents, and the acts that guides these precedents. And that's why people are saying this is dangerous. But if you know it now, I've told you, you've listened to me, you know that. I'm just going to look at this. In the absence of a contractual relationship between the parties, these rules do not apply, and the course of action will have to be actio legas aquila. So that's in the absence of a contractual relationship. Why? Because contract is law. What do I mean? Look at my clips on advanced contracts. Hopefully I'll talk about it. I will say this now about it. When you draft a contract between parties, the moment they sign it, they have created contract law within that contract. And if it's not contradicted to any legislation or against public interest, that law will govern the contract. Specifically the cost clause, the legal cost clause in that contract. But in the absence of it, then we're going to fall over to common law. Depositories defenses, let's have a look at it. This is if we are acting on behalf of the client in terms of the defense. In defense, a depository may allege and prove the returning of the thing. I gave it back. You're lying. I've got sons and they always borrow my tools. I say, where's my tools? No, Dad, we brought it back. We put it in the garage. And they don't talk nonsense with me. Come and show me. And then they put it in a place where I didn't look. So allege and prove the return of the thing. I see my neighbor still have my trailer. It's standing in his yard. I looked over the wall this morning before I came here. Where's my trailer? Because he's borrowing it and he's standing on the other side of the wall. So we don't have a contract in place. So the actio legas aquila is paramount there. And if there's a problem, then that's the way we will deal with it. I've got a good neighbor. Don't worry about it. Allege and prove that a thing was destroyed or damaged. And in the case of gratuitous deposit, the absence of gross negligence. In the case of a deposit for remuneration, that the destruction or damage occurred without fault. Allege an exemption of owner's risk clause. In the case of a dispute about the existence of such a clause as part of the contract of deposit, it will be for the depositor to replicate and prove that a clause was not a term in a contract. Now we're also talking about implied terms. We're also talking about tacit agreements. The position is different when a claim is in delict and the defendant wishes to reply on the exemption clause. In such instances, it will be for the defendant to allege and prove the exemption clause. The scope of protection given by such a clause is a matter of interpretation, and don't get afraid when I say constitutional interpretation. You will be surprised that we measure the drafting contracts against the Constitution. Go read up on that. That's very important. When we talk about advanced contracts, we'll show you there. The depositor may plead that a clause did not protect the depositor because of fraud. For example, you can see that in the SA versus Tavares case and the King's Kai-Hara case. So that is important. And then lastly, allege and prove an amendment to the agreement by the intention of an owner's risk clause. Now, what you do is when you look at the precedent example in AMLers, they give you the short version of this. And this is the meat you have to build in. And most people take this precedent and build in what they think should go in because they are lazy, really lazy, just to read all these court cases and what must be there to set up a lawful and legal particulars of claims. Now, I've spoken a lot about exemption. Just quickly let's look at the exemption clause. If there is an exemption clause stipulating, for example, that a deposit take place at the owner's risk, the owner must allege and prove facts that place his or her conduct outside the terms of the limitation in order to claim damages. So exemption can literally kill your case. And you can then look at the Tavares case there always. Don't worry about it. I'm going to post all these court cases and acts online for you. They're on the eLeader platform. Right, so how does this look? How does this look? Let me read you on page 167, then a precedent of a POC in terms of this delict. And the first one we're doing is for the return of the article, deposited, then owner's risk, and then absence of negligence. All right. And they throw short versions. So you've got to apply your mind to put up a particulars of claim out of these precedents. The first one, for the return of an article, deposited on date at so-and-so place, and by virtue of an oral agreement between the parties, plaintiff deposited with defendant a motor vehicle with registration number so-and-so to be kept by defendant pending plaintiff's return from abroad. The value of the plaintiff's vehicle at the time of the deposit was so-and-so, and you're going to have to put the annexure there. It's going to be a fair market value by a valuator in vehicles. Upon plaintiff's return, the defendant was unable to return the vehicle to the plaintiff. Wherefore plaintiff claims return of the motor vehicle with registration number so-and-so. Alternatively, payment of the sum of so-and-so being the market value of the vehicle And I would put there, I would change it because I've got experience. I expand on this at so-and-so date. Remember what we said? The value at the date of the delete. All right. Let me quickly take a sip here. Now, do you see here? Parties is not here. Jurisdiction is not here. Locus standi, well, they say it's the owner, do they? They have to say it's the owner. And maybe there was a letter of demand and all the press are not here. So you got to build this in. This is why presidents are dangerous. But now you know. Just by listening to this, you know, you'll never make that mistake. That was a claim. Now let's go and look at 2, please. Owner's risk. Defendant admits the agreement as alleged, but pleads that, in addition, the parties agreed that a vehicle would be stored by the defendant entirely at the owner's risk. That's a plea. So I put my vehicle there, but it was at my own risk. Absence of negligence. Plaintiff's motor vehicle was stolen by a person unknown to defendant and without negligence on defendant's part. Particularized steps taken to protect object. So what does this mean? This means that you're going to have to say how you safeguarded this vehicle and why you are saying, no, I left it in the front of my yard at a gate. The gate doesn't have a lock on it. Then there's negligence. But I parked it in my own garage and I put a lock on the door. People came in and broke that lock and take it out of there. They broke the front lock on the gate. Then you have a case. All right. So this is the precedence for putting up a post, POC. And if you go to the index in AMBLIS, you'll see it's got almost everything there you need. That's why I like this. But you need to know how to apply it. All right, ladies and gentlemen, we're coming to the end of it now. I'm going to do divorce with you. So we did damages, we did delict, although damages is delict, but we dealt with them independently to give you a kind of idea what this is all about. Now, in this AMBLIS, on page 170, let's quickly go through divorce. I'm not going to go through all of it. You're going to also do your bit, but we will do a precedent on it in terms of a claim and also a divorce alternative. And you can have a look at that. All right. A couple of claims there and so on. All right. Let's quickly have a look at divorces. In general, divorce proceedings must be instituted by way of action and may not be brought by way of application. End of the story. But what do we bring by way of application? The Rule 43 application. So even though we start a divorce with an action, we also don't have to do it. You can bring immediately a Rule 43 application also. I just found it easier for myself to bring the action first. But a lot of my colleagues disagree. They say you first bring the Rule 43, and then in terms of the order of the court, you can restructure the action. I never do that. You first bring the action, then in the Rule 43, you tell the court there is an action, and this is the interim relief we want. So that's my stand on it. A degree of laxity as far as the post pleadings are concerned is fairly common. For instance, it's not customary to support the claim for custody of the children by any factual averment supporting the implied conclusion that the interests of the children require that custody be awarded to, say, for example, the plaintiff. So, where do we start with such a particulars of claim? The marriage. The plaintiff must allege and prove a valid and existing marriage. All right, stop there. I had one case, I was divorcing an elderly couple of over 60, 70 years ago. And when we arrived at court, I said to the old man, "Where's your marriage certificate?" He says that he's looked everywhere and cannot find it. I said, "But why don't you phone me?" He says, "Well, sorry, but we're going to go up now." So I say, run over the street from Pretoria High Court to Home Affairs and get a abridged marriage certificate. Came back. He didn't come back. So I went to the judge and I said to the judge in chambers before motion court started, I said, "Listen, I got a problem." It was, those days, it was acting Judge De Jager, a very good judge. I appeared a few times in front of him, a lot of respect for him. He actually made court fun because he listened and he had a good attitude. Very good judge, acting judge, according to me. And I said, I have the pastors, you know, in the book you write and they give you the certificate that you married. And he said to me, "You know what? Present it in court to me and make an argument." I said, "Well, okay." So I'm now confused. So I go back and I go down and there the old man is standing, says, "Well, I stood there in a row. I saw the time is coming out. Maybe we will come back another day." I said, wait. The judge said something strange to me in chamber. So I went out and I in court presented my case. And I said, well, I submit this is proof enough because the memo has been signed. And of course, the fact that a divorce is not opposed. That is very important. Otherwise, I might not have gone away from it. I handed it up. And then he told all the advocates in the motion court, this is valid. And he explained why. He actually gave a little bit of lecture there. Great judge. Great judge. And that's how we got that through. So you must prove that. You must prove there was an existence of a marriage. The best evidence of the conclusion of marriage is a marriage certificate issued by the relevant authorities. They say the best evidence. We got away with that certificate. In terms of the recognition of Customary Marriage Act, the following are for all purposes recognized as marriages. Marriages are valid marriages at customary law and that existed at the commencement of the Act. That's before 15 November 2000. You got to say this. You got to say this in particulars of claim. Otherwise, how do you prove it? Customary marriage entered into after the commencement of the Act that comply with the Act's requirements after the 15 November 2000. If a person is a spouse in more than one customary marriage, all valid customary marriage entered into before the commencement of the Act, same date, ne? If a person is a spouse in more than one customary marriage, all such marriages into after the commencement of the Act that comply with the provisions of the Act. And there's a couple of court cases there for you. So, most advocates and beginners attorneys would say, oh, this is a difficult POC to put up. No. Here you see what the requirements is. If you follow it and you draft it into particulars of claim, this becomes something easy. Courts, divorce action may be instituted in a high court or in a regional court, which has the same jurisdiction as any high court in relation to matrimonial matters, nothing else. Ne? Now, this is important. Ne? I still go to the high court because that's my main house. It's my house. I like to act there. So if I have influence, if an attorney phones me, they usually ask, where do you want to do it? If we give it to you, I'd say, no, I love the high court. But I've done a few in the regional court. Your jurisdiction is general. The plaintiff must allege and prove that a court has jurisdiction by virtue of one or other of the following grounds of domicile or residence. All right, let's have a look at it. Jurisdiction, domicile. At least one of the parties to the action must have been domiciled in the area of jurisdiction of the High Court on the date on which the action was instituted. Domicile by way of origin. Domicile of choice or one of proximity. All right, so that's also important. Then jurisdiction of residence. All of that is domicile, the first part. At least one of the parties to the action must have been ordinarily resident in the area of jurisdiction of the High Court on the date on which the action is instituted and must have been ordinarily resident in the Republic for a period of 1 year immediately prior to the date. That's another jurisdiction. You have a counterclaim jurisdiction. The court that has jurisdiction in relation to a claim has jurisdiction in respect of a claim in reconvention or a counter application in divorce action concerned. Now be careful. A counterclaim doesn't mean I'm opposing the divorce in total opposition. Counterclaims means I might say, well, no, I don't agree with this. I'm claiming from you maintenance, not you from me. So there's a situation, there's a certain sense you can do that. Or I'm claiming custody. A counterclaim is not always totally just opposition. Jurisdiction, other issues. The Divorce Act does not confer jurisdiction other than in divorce proceedings and matters incidental thereto. It does not confer jurisdiction in commercial disputes between parties unless the disputes arise from the marriage relationship itself, and many times it does, especially if they were big businesses and so on, and we get those disputes all the time. And then, of course, your jurisdiction in your regional courts. A regional court has jurisdiction if at least one of the parties is domiciled in the court's area of jurisdiction on the day on which proceedings are instituted, or it's ordinarily resident in the court's area of jurisdiction on the said date and has been ordinarily resident in the Republic for a period no less than 1 year immediately before the date of that specific date it been issued in court. And then marital regime. The marital regime is determined by the lex domicilii at the time of the marriage, and that's the one you use the most. The most. There is one they're not mentioning here. Interesting, eh? And that is the one by consent. The parties can agree to any consent within the High Court due to any place to adjudicate upon their marriage. So that's one they're not saying here. All right, and then I talk about the children. That is also important there. The plaintiff must allege whether they are dependent on minor children. It is proper to make allegations regarding the welfare of these children, since the degree of divorce may not be granted until the court is satisfied that provisions made for or contemplate in respect of welfare of any minor or dependent child of the marriage are satisfactory or are the best that can be effected in the circumstances. Also, the degree of divorce may not be granted if an inquiry was instituted by the family advocate until the court has considered the report and its recommendations. I had a case now up to last year, where the family advocate kept the case back for over 8 years, and I have a serious problem with that family advocate. That's where I believe a family advocate is overstepping his boundaries, totally. And the reason I'm always also saying that is because it was ridiculous, his reasons, totally ridiculous. A party wishing to claim sole guardianship ought to make allegations supporting this claim. Why? Why not joint? Why sole guardianship? It's not customary to make allegations in the body of the particulars of a claim relating to the amount of maintenance required. Maintenance claimed without any antecedent. Now, antecedent means we're not going to say anything about it, but at the end, in the prayers, we'll just claim it. And then later, if we have to go on trial with this, then we can elaborate more on it. Then I talk about a family advocate. You can have a look at that. The grounds of divorce is so false for me. Guys, I don't know if some of you have already been involved with divorce cases. Lost mutual trust, no communication. Lost mutual trust, love. Party has moved out. It's very rarely that you see the true reasons. He's been sleeping around. He's beating me up. He's stealing my money, my income. He's verbally abusing me, psychologically abusing me, whatever the situation might be. And so I urge you that if people get divorced, that be very careful to tell them what to say as the grounds of divorce. There's about 4 of them. Everybody uses it. And I found in my years that I really get upset because they word for word the same in every divorce. Really? So every divorce in a country is precisely 99% precisely on the same 4 points, sometimes 5. Come on. Grounds of divorce. The plaintiff must allege and prove the grounds on which the degree of divorce may be granted. When time, date, and place of other person's identity is relevant or involved, details thereof must be given in the relevant pleading. You'll find that in Uniform Rule 18 sub 8. Further, ground of divorce, irretrievable breakdown. There you go. Mental illness and unconsciousness, that I can understand. A trivial breakdown. A plaintiff who wishes to reply on this ground must allege and prove facts that testify the court a marriage relationship between the parties to the marriage has reached such a state of disintegration that there is no reasonable prospect of the restoration of a normal marriage relationship between them. And I don't know how many times I've said this in court, that there is no reasonable prospects of the restoration of a normal marriage relationship between them. That is always my final submission. As I've said this thousands of times in the years I still did divorces. The court may accept as proof of a rebel breakdown of the marriage evident that the parties has not lived together as husband and wife for a continuous period of at least 1 year, immediately prior to the institution of divorce action. That's important. The defendant has committed adultery and the plaintiff finds is irreconcilable with a continued marriage relationship. That's it. He slept around. That's a good one, if it's the truth. The defendant has, in terms of the sentence of court, been declared a habitual criminal and is undergoing imprisonment as a result of that. So there you go. That's much more specific. I believe in that. Then maintenance for the spouse. Let's quickly have a look at that. A claim for payment of maintenance normally has to antecedent in the body of the particulars of claim. The factors relevant in determining whether maintenance should be ordered and what amount should be are the existing or prospective means of each of the parties, their respective earning capacities. This is so important. People just pick amounts out of the air. You have to consider this and discuss this with your clients when drafting that POC. Financial needs and obligations, the age of each of the parties, the duration of the marriage, the standard of living of the parties prior to the divorce. The standard of living of the parties prior to the divorce. Remember one thing, the courts accept that when people divorce, the standard is lowered. You don't have that full income anymore. You cannot sustain that standard. Everybody's going into their own direction. And when parties are vindictive, they want the status quo to remain. They can't. Their conduct insofar as it may be relevant to the breakdown of the marriage, the terms of the redistribution order, and any other factor which, in the opinion of the court, should be taken into account. And I'm happy they're leaving that open because you can say extra things that's not in here. So I want you to go through that when doing a divorce. Remember, this is kind of important, isn't it? As a new advocate on the block, what are you going to be doing the most? You're going to do a lot of divorces to start off with. You're going to do liquidation applications, sequestrations applications, etc., etc. That's where you're going to do most of your motion proceedings work, because you need to get used to this. And if you go into criminal court, which I advise you do, I love criminal court. It's an aggressive, hostile environment, but I love it there. And there you will do petty theft, shoplifting, drunken driving. You'll do, although that can be complicated too. And that's where you start off. You start off with those things. Settlement agreements, propriety claims. You can go through that. You need to put up the parental agreements there. That is always difficult. You're going to be careful there. But there are so many templates. And in the Regulation 6, remember, you're becoming an advocate. That's Regulation 7. But we've given you all the source documents of Regulation 6. High court, low court, matrimonial, personal injuries, insolvency. Man, there's a lot of them. You must go through all of them, because they're the same for Regulation 7. And they teach you to draft, especially Mac Court and High Court. So if you can do a High Court and Mac Court, and you need to do a RAF claim, then that's where you go. You take the personal injuries guide under Regulation 6 in your resources, and you combine them with the relevant court you're in, and voila, you've arrived. And we've given you everything. All these documents, all these templates are there. If you, the moment you become a pupil, you can work. You can do this. And you don't have to guess. We are giving it to you. And I believe in that. When I became an advocate, it was a game of embarrassment. Hey, guess if you're right. If not, the judge is going to embarrass you in front of 60 other advocates in a motion court. That's the games they played with us. Not anymore. We are empowering you with the tools to get there. You must just work hard, get beyond September, get accepted by a chamber or independent advocate, and make it work for you. Okay. Particulars: a party claiming division, transfer, or forfeiture of assets in respect of the marriage out of community property is obliged to give details of the grounds on which the claim to the division, transfer, or forfeiture is based. So that is important. Sometimes you're in a deadlock. They say, I want this, you can't agree. Then you have to bring in appoint a liquidator that's going to liquidate those assets, and they'll actually sell it. You'll be paid out in monetary value. So you must always advise your clients to rather agree than not agree. And the last thing I want to discuss before I'm going to do a particulars of claim with you is the religious constraints. If it appears that despite the degree of divorce, the spouses, or either one of them will, because of religious prescripts of the religion or those of the spouse concerned, not be free to remarry unless the marriage is also dissolved in accordance with those prescripts, or unless a barrier to the remarriage is removed, the court may refuse to grant the degree of divorce unless it is satisfied that a spouse in whose power it is to have the marriage so dissolved, or the said barrier so removed, has taken all the necessary steps to have the marriage so dissolved, or the barrier to the remarriage of the other spouse removed, or the court can make any other order that it finds just. It's a restriction. It's a fundamental and constitutional restriction to do something like this, and the court must make certain then that works out right. And you can look at 1999, the Armour versus Armour case there. All right, are you ready? Let's quickly read a short POC on a claim for a divorce of marriage in community of property. Listen to how I'm reading this. Okay, so here they actually give you the full precept. And I appreciate that more, because for newcomers to the practice, in most of them, they don't do it. And then, you know, if you haven't listened to all my clips and you've gone through a program like this, you won't know and you fall around. But here they give everything. The plaintiff is full names, what is the gender, occupation, residing at. The defendant is full names, what is the gender, what is the occupation, residing at. The parties were married to each other on the date, at what place, the community of property, in community of property, and that marriage still subsists. Remember, only on the day the degree of divorce it issues, the marriage stops to subsist. The parties are domiciled within the area of jurisdiction of this honorable court. You've got to say a lot of things there. By consensus, they picked the court. They were married in this jurisdiction. We just spoke about it before this. Do you recall? 5A, from the marriage between the parties, so many children was born. You have to give all the names, dates of birth, preferably, not preferably, you have to do it. I always do it. They are still minors and are presently in plaintiff's care or in the defendant's care. B, it would be in the best interest of the children if plaintiff or the defendant are awarded custody of the children. Even if you have joint custody, it's a difficult situation because you create two homes, but I have seen that one of the parents, I don't know, it's by natural evolution of being a human, that they became the main one, but actually joint means there's two places there. Clothes at both places, toys at both places. It's difficult, but then when one party lives in Johannesburg and one in Cape Town, obviously it's problematic. You have to deal with that. It would be in the best interest of children, yes, all right. And then the report of the family advocate is annexed because there's minors. You cannot divorce anybody if there's minors without the family advocate's report. You know that, right? Number 6, the marriage relation between the parties broke down irretrievably, and there is no reasonable prospects of the restoration of a normal marriage relationship between them for the following reasons. A, defendant has assaulted plaintiff repeatedly, that's it. Not this other bullshit of lies, the truth. Defendant committed adultery with name, on date, and at place, and the plaintiff is not prepared to condemn or accept it. There she goes. There he or she goes. I tell where it happened. The parties have to live together as husband and wife for a period of. The parties have not lived together as husband and wife for a period more than 1 year. All right. So that's very important. So if you make an allegation, you have to substantiate it. Now let's go to the prayers. Wherefore plaintiff claims a degree of divorce. Easy. Short. End of story. Custody of the minor children born of the marriage to be awarded to the plaintiff or the defendant, or joint custody, depending on what direction you're going to go. Maintenance for the children in the amount of per month per child, if applicable, if there's minor children. Maintenance, even if there's major children, this can be done. There's a possibility of that. Maintenance for plaintiff in the amount of so much per month, if applicable. One of the parties is maybe 80 years old, 60 years old. She cannot find a job. You're going to pay maintenance for her. A division of the joint estate and order that defendant forfeits the benefits from the marriage in community of property. And a division of the joint estate means a liquidator or a curator or a trustee or somebody is going to be appointed there to get rid of it because they cannot agree. And then cost of suit. And after cost of suit, you can always say there further or alternative relief, like we said in our first clip. Here's another one, alternative for a divorce. The plaintiff, full names, gender, occupation, residing at. The defendant, full names, gender, occupation, residing at. Alternatives relating to the nature of the marriage, post-nuptial contract. The parties were married to each other on date and paid in community of property, but in terms of Section 21 Act so-and-so, the parties into a notarial contract in terms of which the marriage was deemed from its inception, from the date of the contract, to be out of community of property subject to the accrual system, the marriage shall subsist. Just last year, I brought an application for a post-nuptial agreement 8 years after they were married. So then this becomes important. That's a post-nuptial contract. Out of community, you can say that the parties were married to each other on date and so place out of community of property, and the marriage still subsists. If they did it before they got married, you can go there. Out of community plus accrual system, remember that other one was not in. The parties were married to each other on date and place out of community of property and subject to the accrual system as defined in Act 88 of 1984, and the marriage still subsists. So you've got to say these things. Alternatives to jurisdiction, the domicile, the residence, I'm not going to go through it again, the mental illness, the unconsciousness or grounds for divorce, and here you have to be specific. For example, let's look at one, just to be clear. Unconsciousness as grounds for divorce. The defendant is in a state of continuous unconsciousness by reason of a physical disorder, and you have to state precisely what it is. There you will attach a doctor's report. The defendant's unconsciousness has lasted for continuous periods of, they say, yeah, 6 months. It can be longer, shorter, but I say at least 6 months, so that's the trend. Prior to the institution of divorce action, there is no reasonable prospect that the defendant will regain consciousness. Again, a medical report to that effect. All right, so it's just that you're going to say it. You're going to give the court something to work with. Wherefore, plaintiff claims a degree of divorce, custody of the minor children born of the marriage logically, maintenance for the children in amount of so per month per child, if applicable, that will come out of his estate because he's not working anymore, he's unconscious. Maintenance for plaintiff to the amount per month, that will come out of his estate. Cost of suit. So that's on the foundation of divorce because he's not deceased yet. Do you understand how this operates? And then I'm going to do another one with you. I'm going to do another two with you, and then this clip is over. Claim divorce and specific performance or the provision of the antenuptial contract. Give me a second or two. All right, I'm back. Human factor has taken over again. Let's look at a claim, a divorce, and the specific performance of the provisions of the anti-nuptial contract. We have the plaintiff, we have the defendant, same thing as before. The parties were married, same before, they were married out of community property and so on. Then a jurisdiction, precisely the same. You pick one, you run with that. You see, we're getting clever now. We don't have to see it over and over again. And then 5A. From the marriage, the children, you say all of that. Best interest, where they should go. And a family advocate because there's minors. 6. The marriage relation between the parties broke down irretrievably and there is no reasonable prospect of the restoration. We have done that. In terms of the anti-nuptial contract entered between the parties, the defender undertook to deny the plaintiff as her sole and exclusive property, and then you have to specify it. A copy of the contract is annexed. I always annex anti-nuptial contract or a post-nuptial contract or a contract registered, a notarial contract registered. Always, always, always. The defendant has failed to comply with this undertaking. All right, so then what is the order? What is the prayers? We have for plaintiff praise and claims, a degree of divorce, custody of the children born to the marriage, maintenance children, maintenance plaintiff, and order that the defendant comply with the anti-nuptial contract and specify. There you have it. Cost of suit, and just then take it further there. So that's good, eh? Now, what about the claim for redistribution in terms of paragraph 7? In paragraph 7, remember, we want to enforce the anti-nuptial contract is not complying with. What about an alternative to that in terms of redistribution? In terms of the anti-nuptial contract entered between the parties, the community of property, community of profit and loss, and accrual sharing were excluded. No agreement exists between the parties in respect of the division of their estates. Usually in court, you will say they've agreed, it's finalized, or they find or whatever. During the marriage, plaintiff contributed directly and indirectly to the maintenance and increase of the estate of defendant by rendering the following services. And then you have to detail them. And by saving expenses that would otherwise have been incurred. For example, staying at home. There is still wives that stays at home. There's husbands that stay at home. That means there's no expenses that has to go out to hire domestics or other service renderers to facilitate those processes. And there can be 100,000 other reasons too. As a result of the foregoing, it would be just an equitable if, and I say in brackets 40%, but that's up to you. You're going to have to determine if 20%, 80%, 60% of the defendant's assets be transferred to the plaintiff. There's the right way of doing it. And then, and of course, an alternative prayer you can work in there is an order that in brackets 40%, you'll have to decide of the assets of the defendant be transferred to the plaintiff, and that's the way that then operates. And the last one I would do for you before we break here, and then you'll see 2 later clips from me. One, how to draft a legal opinion, and then I'll come and talk to you a little bit about customary law, and another independent clip. Claim where issues settled, an additional paragraph. The parties have entered an agreement relating to the custody control of the minor children, payment of maintenance, a division of the estate. A copy of the agreement is annexed here too. And another alternative prayer you can work in there where plaintiff claims a degree of divorce incorporating the provisions of the agreement annexed here too. And then that's what we also used to do with the settled agreement many, many years ago. Now, ladies and gentlemen, that is clip 1 and 2 in the drafting of pleadings. And I did much more than was instructed because you are on a self-evaluation path. But I hope that you learned something from me. From my years of experience, whenever I read something and I pick something up and I say something extra there, I want to leave you with this thought before you look at more of my clips. Stay positive. Get your operational tools in place. Go and buy the Hussein book. Go and buy Haram's Amless Presidents of Pleadings. Don't do assignments over, multi-choice assignments over when you have about 50% move on. If we declare you non-competent on a practical examen, most probably on the practical part where you have to draft for us as fast as possible, go and look at it and correct it. We will issue a general report and say that on all of the practical assignments that did not reach competency, in general, these mistakes were found. And then you must just go and look at that. And do go and look at Regulation 6, the sources there. In those Regulation 6 sources, you'll find a lot of exercises. Some have marks with them, some have not marks with them. Most of them you won't, we're not giving you answers on them. It's Regulation 6 training. You don't have to do them. They're not compulsory. You have more than enough to do. There's another 7 practical assignments coming. You're going to have 10 practical assignments you have to submit. We're going to keep you going because September you have to pass. But you can go look at it if you have time. If you think you have time, you go through it. But you must not submit any of those exercises. All right, that is not relevant. What is relevant there is the course content, the templates there, the practical drafting skills you pick up in terms of the specific subject matter of your specific case. All right, is it the insolvency? Is it the personal injury claim? Is it matrimonial matters or whatever that situation is? And that is how we are approaching it. All right, so yeah, and then I'll see you guys, hopefully 4 sessions of 2 hours each. I'll see you guys 4 times up to the end of, if I'm not mistaken, August, in which I'll just come and reassure you, listen to what you want to say to me. Maybe you want to ask a question. I can tell you nothing about the exam, but I will be there for encouragement. And I'm just waiting after the 15th of this month, after registration is locked down, for a name list so I can put you in teams with a team leader. And then you have to form groups, WhatsApp groups, whatever the situation is, and you have to help each other. And I will make an announcement on the announcement tab to that regard, so that all your questions first goes into the group, to the team leader. You try and resolve those questions first. And then in those 2-hour sessions, 4 times, we can just look at questions and stuff you want to ask that you couldn't resolve within your specific group. All right. And that's it from me. All right, guys, be positive and enjoy it. Still, according to me, you've made the best decision possible to become an advocate. It is prestigious. Everybody's going to be very proud of you. And if you work hard, you will make it. If you slack, you're going to be disappointed. I'll see you in the next recording. I'm out of here. Got to stop it now.